branch, district judges versus Donald J. Trump. This hearing is a joint undertaking by the Subcommittee on the Constitution and the Subcommittee on Federal Courts because our country is facing a constitutional crisis, a full-blown judicial assault on the separation of powers that strikes at the very foundation of the Republic. What we're witnessing is the rise of judicial lawfare from the bench. One unelected district judge sitting in a courtroom in San Francisco or Boston or Baltimore can now issue a nationwide injunction that ties the hands of the President of the United States for all 330 million Americans. That's not law, that's judicial tyranny. President Donald Trump was elected by over 77 million Americans with a constitutional mandate to govern. These district judges, they were not elected. They were appointed by one individual and confirmed not to legislate, not to govern, but to apply the law. And yet, far too many of them have abandoned that role. They've stepped off the bench and into the political arena, issuing sweeping edicts that impose their policy preferences on 340 million Americans. Let's walk through just a few of the most egregious recent examples. Economic policy. In New York City, the Court of International Trade struck down all of President Trump's tariffs under IEEPA, declaring that they exceeded executive authority. It was not judging, it was judges replacing the president's judgment on declaring a national emergency. And of course, that ruling was almost immediately stayed by the Court of Appeals. Deportation policy. In Baltimore, the chief judge for the District Court of Maryland issued an order preventing the removal of illegal aliens detained anywhere in the country, granting 2 days of automatic protection to anyone who files a habeas petition in Maryland, all without a hearing or legal findings. This single Maryland judge dictated national deportation policy and then tried to claw back the damage by amending the order. As chairman of the Subcommittee on Federal Courts, I'm investigating this overreach, and I've sent a letter to the Judicial Conference of the United States. But the judges did not stop there. In D.C., a judge blocked the federal government from requiring proof of citizenship to vote, overriding election integrity laws across all 50 states. In Boston, a judge weighed in on birthright citizenship, deciding a question of nationwide consequence for millions of illegal aliens, despite the plaintiffs being solely one pregnant mother and 2 nonprofit organizations. That's absurd. That is policymaking and legislating. That is not adjudication. In Boston, a different judge blocked a Department of Energy rate cap, handcuffing efforts to lower taxpayer costs for energy research. In Rhode Island, a judge ordered the federal government to immediately disperse tens of millions of dollars under the Inflation Reduction Act and other programs. The Department of Energy alone was forced to release $50 million by judicial fiat. In San Francisco, a judge mandated that the Office of Personnel Management rehire all terminated federal workers and restricted future firings, effectively turning the judiciary into an HR department. Yet another Maryland judge halted orders intending to stop funding for institutions mutilating minors through so-called gender transitions. These deeply consequential decisions were blocked not by voters, not by Congress, but in each instance by one unelected judge. And it doesn't stop there. Since President Trump returned to office in January, there have been over 40 universal injunctions issued against the federal government. That's in 4 months. 35 of those 40 came from the same 5 judicial districts. Let's put this into context. In the first 150 years of the Republic, 0 nationwide injunctions were issued. 0. That's for 150 years. In the entirety of the 20th century, 27 nationwide injunctions were issued. That's over 100 years. Under Presidents Bush, Obama, and Biden combined, 32 nationwide injunctions. Under President Trump's first term, 4 years, 64 nationwide injunctions, and now in just 4 months, we're already over 40. In 4 months, the Trump administration has seen more nationwide injunctions than the entirety of the 20th century and more nationwide injunctions than Presidents George W. Bush, Barack Obama, and Joe Biden combined. This is not normal. This is not justice. This is an orchestrated campaign of judicial obstruction. Joe Biden, when he was president, nominated to the bench radicals. I have said, only slightly tongue-in-cheek, that Joe Biden did something I used to think was impossible. He made me miss Barack Obama. But by comparison, the Biden judicial nominees were far more extreme and radical than they were under Obama. They sought out radicals who would implement policymaking from the bench, and they are doing precisely that. That is not democracy, and that is not our Constitution. This hearing is to highlight the effects of this judicial tyranny, of single judges deciding they know better when it comes to policy than do the voters of America. We need to defend democracy. And with that, I recognize Senator Whitehouse.
Thank you, Senator Cruz. When I chaired the subcommittee on federal courts, we held hearings on the influence on our judiciary of dark money from the fossil fuel industry and from creepy billionaires. My Republican colleagues weren't interested in helping solve that problem, but those hearings were based on facts. Years of financial disclosures showed a secret billionaire gifts program for amenable Supreme Court justices. Written evidence suggested a justice may have failed to pay taxes on a $270,000 loan that was forgiven, and that false statements were made about a yacht. A mountain of evidence revealed President Trump outsourced to billionaires and their dark money fixer, Leonard Leo, the selection of his judges and Supreme Court justices, which President Trump admitted just last week. Apparently, Leo also, and I'm quoting Trump here, openly brags about controlling the judges his creepy billionaires got appointed. This hearing will be different. A lot of hypocrisy about nationwide injunctions against the Trump administration after Republican colleagues cheered the nationwide injunctions that courts issued against the Biden administration. Indeed, some colleagues filed lawsuits asking for nationwide injunctions against the Biden administration. But now they're shocked that there are nationwide injunctions. Here are some facts everyone should bear in mind during this hearing. Fact number one, Donald Trump's administration is engaged in unprecedented lawlessness, period. In less than 5 months, President Trump has issued almost as many executive orders as President Biden did during 4 years in office. Many are flat out on their face illegal, as any first-year law student could tell you. Trump tried to end 14th Amendment birthright citizenship. He tried to punish law firms' First Amendment rights to associate with his perceived political enemies. His fossil fuel minion at OMB, Russ Vought, withheld millions of dollars that Congress had appropriated under Article 1. More than 20 years ago, originalist icon Scalia wrote about how illegal that is. The madcap pace and roughshod lawlessness of Trump's executive actions mean district judges across the country are striking them down, not because of judicial obstruction, because he is breaking the law. Hearings like this prop up a narrative that bad courts are stopping dear leader Donald Trump because some cabal of Democratic judges is out to get him. Wrong. The reality is much simpler. He's breaking the law and doing it a lot, and judges are doing their job. It's not just me saying that. Trump-appointed judges from across the country have struck down his illegal actions, holding, for instance, that Trump can't punish the AP for its reporting, that his misuse of the Alien Enemies Act is illegal, and that the administration can't withhold billions of appropriated public health funds. Trump judges, hardly a liberal conspiracy. As it tries to prop up Trump's illegal orders, the MAGA Justice Department is fast destroying its reputation with judges who've said about DOJ arguments, bad faith, shoddy, an admitted lack of any evidence whatsoever, deliberate evasion. Shocking not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. And the prospect of contempt findings looms. Fact number 2, failing in court, Donald Trump and his allies attack judges and their families. Trump has called judges who ruled against him communists, USA-hating, and monsters. A Republican in Congress put up a wanted poster with judges' faces outside his office. Elon Musk and Laura Loomer have used X to fire up the right wing's flying monkeys about judges, even adding photos of family members in a seemingly coordinated campaign to harass and intimidate. A test is coming of MAGA Attorney General Bondi. Will she let the Marshal Service investigate these threats and their orchestration? There's plenty of predication to look into conspiracy, aiding and abetting, or RICO enterprise liability. Will she let them? Which brings me to fact number 3. In a 6-week period from March through April, 162 judges received threats to themselves or family members of harassment or violence. 162. A pattern was evident. Many had ruled against Trump and then were targeted. The latest tactic is a campaign to send pizzas to judges or family members' homes using the name of the murdered son of a federal judge. It's not clear yet who is behind that campaign, but it's not hard to figure out the message. Stop ruling against Trump or else. These attacks have gotten so bad that the Chief Justice issued a statement, and the Judicial Conference formed a Judicial Security and Independence Task Force. Now I'd like to see some sign that the threats are being duly investigated. To the extent that this hearing encourages that animus further, it is deeply regrettable.
I thank Senator Whitehouse and now recognize Chairman Schmidt.
Thank you. Thank you, Senator Cruz. As chairman of the Subcommittee on the Constitution, I'm glad that we've convened this hearing. Universal injunctions effectively didn't happen for the first 200 years of our Constitution. Yet they become a fixture in our legal system in the last 20, especially when Donald Trump occupies the White House. The courts can play an important role in reining in an executive branch that's out of control. This is especially important when reining in actions by unelected, unaccountable bureaucrats who act outside of the scope of their congressionally authorized authority. But what happens when Article 3 has no limits? As listed in the hearing's title, Alexander Hamilton called the judiciary the least dangerous branch in Federalist 78. And historically, in Federalist 78, Historic was responding to the anti-federalist Brutus, who was raising the alarm bell over the seemingly unchecked power of Article 3 to subvert the will of the people and the rights of citizens. Hamilton responded that judges will be forced to behave because nothing guarantees that their orders are enacted. Judges can't raise an army. They can't collect taxes or duties. As Hamilton said, the judiciary must ultimately depend on the aid of the executive branch to enforce its judgments. To date, the Trump administration has followed every court order, enforced every judgment. It's no one's desire to put Hamilton's theory into practice. That is why this hearing is so important. We are not a juristocracy. We do not want the judiciary to subjugate itself. We want to keep it from subjugating others. I agree with Hamilton that there is no liberty if the power of judging is not separated from the legislative and executive powers. But this runs both ways. There can be no democratic accountability, no Republican government with an overly activist judiciary that allows over 600 judges to wield limitless power. On one particularly troubling example, district court judges have not been assigned cases randomly or transparently. In March, Chief Justice Boasberg, right here in D.C., has found himself into 4 major Trump cases, a statistical impossibility. Boasberg took over the Alien Enemies Act and ordered planes to be turned around in the dead of night, despite not being the emergency judge on duty that night. It seems clear that as chief judge, he has play and he wants to be able to grab cases for himself. I've had firsthand experience with this non-random case assignment in our federal appellate court system. When I was Attorney General of Missouri, I often found myself litigating in the 8th Circuit, a circuit of unique makeup. Of the 11 judges in the circuit, 10 have been appointed by Republicans. Yet, the one Democrat appointee, Judge Jane Kelly, found herself hearing nearly every political sensitive case in the circuit. Time after time, case after case, miracle after miracle, for the Democrats, Judge Kelly would be there for nearly every politically sensitive case. This was not due to the good luck of Judge Kelly. The circuit clerk's office, which assigned cases to appellate panels, was filled with her former clerks and ideological compatriots. In practice, they set the nationwide policy by rigging case assignment. Another issue is the universal injunction is a judicially created remedy while Congress set up a procedure for group relief under Rule 23. As Solicitor General John Sauer recently argued compellingly, the proper avenue for group relief is under Rule 23 class actions. Rule 23 was designed to ensure a structured and fair approach to broad legal challenges. I'm hopeful that the Supreme Court will curb injunctions to restore proper judicial limits and respect the separation of powers. A district judge blocking deportations is as absurd as directing military strategy. This is activism, not judgment, not the rule of law, and it undermines the voters' mandate to secure our borders. Enough is enough. We must act here in the Senate to fix these issues. Article 1 isn't alone in this. The Judicial Conference and the Supreme Court must get their houses in order as well. Does our Constitution establish a judiciary that resolves cases or sets policy? In this committee, do we confirm judges to take the bench or to take the podium? The founders clearly intended the former. It's time for a reset. The American people elected President Trump to secure our border and restore our nation. I look forward to the testimony of the professors, and I urge this committee to advance reforms that uphold the separation of powers.
Thank you. I now recognize Ranking Member Welch.
Thank you very much. You know, the concrete issues of a universal injunction or forum shopping are things that we can address. But there is a context that we're all operating in, and this is where I disagree with my colleagues, particularly Senator Cruz and his recitation of what he saw as a judicial rampage. This moment we're in our country is testing whether the separation of powers, 3 co-equal branches of government, shall endure. That's really the question. We've seen an abdication of constitutional responsibility by the Congress. It's appalling. Ceding to a president the ability to impound funds, something that was declared unconstitutional in the Nixon Doctrine. Ceding to the president tariff authority, which in the Constitution belongs to the policymakers in Congress. Just 2 examples of Congress ceding its constitutional authority. That's done willingly by my colleagues in the House and some in the Senate. We should reassert our authority. But the second leg of that, the transfer of authority to the executive, is the rampant attack on the judiciary. And Senator Cruz gave some examples of what he thought was judicial overreach. Each one of those examples, as I see it, was the judges doing their job. They disagreed. And when they disagreed, it was asserted by the president and by the attorney general that they were monsters, they were renegades, they were out of control. It was an ad hominem attack because judges were doing their jobs. And I will say we can deal with the forum shopping, which is something the private bar gets involved in. We can deal with universal injunctions. But the all-out assault on judges, because they make decisions, which is the job it is they have to do. And the decision is, has a president exceeded his authority? The decision is, has the Congress passed a law that deviates from constitutional requirements? Those are so profoundly important to keep that separation of powers and to keep the competition between the three branches so that we don't have absolute power vested in a single person, and that's the chief executive. So when, Senator Cruz, you talk about a judge making this decision about keeping somebody here, it's called due process. I'm for due process. When we talk about judges striking down under the international trade agreement, whether the president has authority to set these tariffs, and it's a three-judge decision, one appointed by Trump, one appointed by Obama, one appointed by Reagan, and they say the president didn't have authority, I would say that is the judges doing their jobs. But what is most profoundly important for the well-being of our country is that the Congress reassert its authority to pass laws, to restrict the executive or to empower the executive, but not to cede our authority to the executive ever. And it's our responsibility to do every single thing we can to validate the legitimate exercise of the decision-making authority of the judiciary. I look forward to this hearing and the testimony of the witnesses. Thank you.
Thank you. I would make two brief observations. Number one, it is interesting as our Democrat colleagues defend these nationwide injunctions that neither of them made any reference to the fact that the number of nationwide injunctions issued in the first 4 months is greater than the entire 20th century and is greater than all of the nationwide injunctions issued against Bush, Obama, and Biden combined, nor did they address the disturbing fact that of the 40 universal injunctions that have been issued in the last 4 months, 35 of them came from the same 5 judicial districts. There is a reason for this. Blue state attorneys general and radical leftist groups are seeking out affirmatively radical judges who they know will impose their own policy preferences. If it were simply, as our Democrat colleagues said, judges following the law, then you wouldn't have to keep going to the same radical judges over and over and over again, because judges across the board should do that. But the litigants know exactly who the zealots are that are on the bench, and that's who they are seeking out. I will also point out that the discussion about the urgency of protecting the safety of judges, listen, I agree. We should protect the safety of every federal judge, but it is interesting because my Democrat colleagues were utterly silent during 4 years of the Biden administration when you had violent mobs outside the homes of Supreme Court justices unhappy with the Supreme Court's ruling in Dobbs, and the Biden Justice Department refused to enforce federal law and protect the justices. And my Democrat colleagues were perfectly happy with Supreme Court justices being threatened if they disliked the rulings that were coming from the Supreme Court justices. Unlike my colleagues, I believe we should protect judges regardless of whether I agree with them or not. We should protect their safety. And every time you hear a Democrat senator talk about protecting judges from acts of violence, you ought to ask them, why did they not have a word to say about the Biden Justice Department allowing mobs to threaten the families and children of Supreme Court justices night after night after night while Biden's Attorney General refused to follow the law? And with that, I'll recognize the ranking member of the full committee, Senator Durbin.
Thank you, Senator Cruz. They asked Winston Churchill after World War II how he thought history would treat him and his conduct of the war. He said, "I'm not worried about it because I plan on writing that history," which he did. Today we see an example of written history, revisionist history from the chairman of with the statement that he just made about concern over the safety of federal judges. I cannot remember a single instance of what he just described, not one, when there were protests and demonstrations before the homes of judges, regardless of who appointed them, Republican or Democrat. Our feeling was they're all entitled to a guarantee of safety to the best of our ability. And that's what I did as chairman of this committee, and I hope that I believe I spoke for the Democrats in that approach. The title of this hearing says a lot. In full, the supposedly least dangerous branch, District Judge versus Trump. The idea being pushed by my Republican colleagues is not only that judicial branch and district judges are dangerous, but they are dangerous for the plain and simple reason that some judges have had the audacity to rule against President Trump. When the chairman from Texas starts talking about the number of times there's been ruling by the court, I have 3 words for him. Flood the zone. Flood the zone. When Steve Bannon was asked, what's the policy, what's the strategy of the new Trump administration, we're going to flood the zone, and they did. More executive orders issued by this president in the beginning of his presidency than any president in history, leading to more court challenges than any president in history. It seems pretty logical to me. By framing the hearing as they have, my Republican colleagues have shown their hand. This hearing is not really about policy or legal issues. Instead, it's about challenging the authority and legitimacy of the judiciary. They are showing their undying loyalty to their leader, the president. This hearing is merely the latest episode in an ongoing effort by President Trump and his allies to undermine the judiciary and intimidate judges who dare to rule against them. In March, the president demanded the impeachment of a federal judge simply because he ruled against his administration, calling him, quote, and I quote, I want you to hear these words, a radical left lunatic, a troublemaker and agitator. In May, President Trump referred to judges who ruled against his administration as, quote, communist radical left judges. 2 days ago, the president posted, and quote, if the courts somehow rule against us on tariffs, which is not expected, that would allow other countries to hold our nation hostage with their anti-American tariffs that they would use against us. That would mean the economic ruination of the United States of America, end of quote. These statements that I've just read are not normal. It is difficult to imagine either President Bush, President Obama, or President Biden using such unhinged, bombastic, and childish language, or calling for the impeachment of a judge simply because that judge ruled against his administration. The reason it's difficult is because Obama, Biden never did anything like this. But imagine if they had, and how congressional Republicans would have responded. They would have shouted about it from the rooftops, posted furiously on social media, and the only person they would have considered impeaching would have been the president himself. But because this president is a Republican, because the president and his allies go after anyone who dares to speak up, because fear of political retribution is now at the core of this MAGA world, my Republican colleagues have been silent as the president has made the statements he has about judges. Instead of rushing to defend the judiciary and our system of government, they are rushing to defend the president. While my colleagues on the other side may try to make it appear as though decisions of district courts against the president are somehow dangerous, in reality, it's the attacks on the judiciary itself that are dangerous, to both the rule of law and to the actual judges themselves. I could go through chapter and verse of federal judges who have been intimidated physically. In fact, deaths that occurred in the Northern District of Illinois. One of my judges, she's now retired, lost her husband and her mother to a litigant who attacked her in her home. It's serious. I don't think it's a mere coincidence that this spike in violence against judges coincided with increasingly harsh rhetoric against the same judges and the president's personal call for the impeachment of a federal judge on March 18th. Some judges and family members have received threats in the form of hundreds of anonymous pizza deliveries to their home. Pizza deliveries? These deliveries are an effort to demonstrate that those seeking to intimidate a targeted judge know exactly where those judges live. Nearly a month ago, I sent a letter to the Attorney General Bondi and FBI Director Patel, asking them to investigate this effort with the pizza deliveries and other threats against federal judges, and to provide information on steps that are taken to protect those judges and their families. I did not designate just Democratic appointed judges or Republican appointed judges, but all judges. Showing the priorities of this administration, I'm sorry to say, I have yet to receive a response from either the Attorney General or the Director of the FBI. In the meantime, I ask my Republican colleagues to join me. Let us recognize that violence begets violence. Threats of violence, whether from the right or left of the political spectrum, are never, never acceptable. People are welcome to debate the merits of any particular judicial decision, but we cannot condone personal attacks and threats against judges who rule against this administration. And we can't allow partisan politics or the latest outrage from the president to undermine the judicial branch and our constitutional order. I yield.
Mr. Chairman, would you indulge me for a moment?
We indulge you every moment.
I appreciate that act of generosity. It's just something you said that I think is actually dangerous and should be addressed, and you're welcome. But when Judge Anderol was killed in New Jersey, the Republican colleagues in the Senate, their outpouring of support, their outpouring of concern, they're willing to work together on a bipartisan bill was extraordinary. It shows the truth of this institution that despite some of the fiery rhetoric that you were sowing, we're really a bipartisan, working bipartisanship. Cornyn and Coons, after the incidents you're talking about, got together and actually passed a bill to better protect our Supreme Court justices, many of whom are friends of ours. You know, Gorsuch and I disagree on a lot of stuff. I knew his wife before he did. We studied together at Oxford. This implication that there was silence when there were threats on their people's houses is absolutely absurd. I remember the rhetoric and the comments, the concern from Coons. I actually distinctly remember you, Chairman, on more than once condemning those attacks on Republican-appointed jurists. To say things like that feeds just the partisanship in this institution and feeds the fiery rhetoric. And it's just plain not true. It's just plain not true. And I think you know that, but we can pull from the record from my colleagues in real time, literally days afterwards, condemning it. There's a lot of substantive things to say here, but to think that the lack of humanity when people's homes are being threatened was not in existence, I think that's unfair and really concerns me that you would say that in the way that you did.
Well, I thank my colleague from New Jersey. I will note, as John Adams observed, that facts are stubborn things. And it is existing federal law, 18 U.S.C. Section 1507, that makes it a crime to protest at a judge's home. And the law provides whoever with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent or of influencing any judge, juror, witness, or court officer in the discharge of his duty, pickets or parades in or near a building housing a court of the United States, in or near a building or residence occupied or used by such judge, juror, witness, or court officer, or with such intent uses any sound truck or similar device or resorts to any other demonstration in or near any such building or residence, shall be fined under this title or imprisoned not more than 1 year or both. That is federal criminal law. Night after night after night, angry mobs were outside the Supreme Court justices' homes, and in the entire course of it, the Biden Justice Department prosecuted nobody. We had the Attorney General sitting at that table, and multiple Republican senators asked him, why are you not enforcing the law? What they are doing is a crime. And my friend from New Jersey said, it is a lie to say we, the Democrats, condone this. I would challenge, my friend, find a single Democrat senator on this committee holding the Attorney General to account for not enforcing this law. I was here at those hearings, and I do not recall a single Democrat senator saying to the Attorney General, you should arrest these people who are violating the law, you should protect the judges. I agree that there was general language against violence, but not a single Democrat senator that I ever saw in this committee was willing to hold Attorney General Merrick Garland to account for flagrantly disregarding the federal criminal law, because the Biden administration agreed with the protesters and I think wanted those justices
Chairman,
harassed at their home.
I really appreciate that you've now shifted the accusation you made earlier. Your accusation was that we were silent in the face of protests at Supreme Court justices' homes. Again, we joined together in a bipartisan way, not only to condemn that, but to pass legislation to extend round-the-clock security protection, literally days. It was introduced May 5th, passed the Senate in a bipartisan fashion on May 9th. So if you're saying that we didn't criticize
Did the
Merrick
Biden
Garland,
DOJ arrest a single person under this law?
you are now changing the
No, that is what I
accusation
said.
that you
That
made.
is what I said.
Again, I'll pull the record.
Did the Biden DOJ arrest even one?
Again,
The answer is no.
my point to you is the accusation that the Democrats on this committee do not care about the safety
All right, so let me
of
ask you
federal
this.
judges.
Should
I
the
did not
Biden
interrupt you,
DOJ
sir. I would appreciate if you let me finish. I am sick and tired of hearing the kind of heated partisan rhetoric, which is one of the reasons why we have such divisions in this country. The attacks we see from the President of the United States of America trolling and dragging judges through is what we should be talking about that puts people in danger. I'm simply taking issue with the claim that you made at the top that people on the Democratic side of the aisle do not care about the safety and the security of judges and said nothing. You said we were silent after people's houses were protested. That is a patent lie, sir. We were not silent. We took action. We joined in a bipartisan way to protect those judges, as was done in a bipartisan way to protect a New Jersey judge after their horrific attack at their home. So I see you now trying to shift the debate to whether we talk to an attorney general. I'm simply taking issue with this accusation that somehow we Democrats are so bad because we don't call out threats to our judicial colleagues. And that is wrong. You could change the argument now that you want, but what you said was patently not true and was, in fact, a patent lie.
So I do enjoy the fact that my colleague from New Jersey raises his voice and says it's a patent lie and says he's doing so in defense of lowering the rhetoric. There is some irony to doing those two together. I'll point out that in the entire course of those remarks, Senator Booker did not dispute the central point I made, which is the Biden Justice Department arrested 0 people, prosecuted 0 people for violating the criminal law, and every Democrat senator on this committee was silent about it. And this was an ongoing pattern for months. And I would note also that the senator from New Jersey clutched his pearls about language threatening judges, and yet I do not recall a single Democrat senator of this committee saying a word when Chuck Schumer went to the steps of the Supreme Court and threatened the safety of the Supreme Court justices by name, Gorsuch and Kavanaugh, and he said, "You have unleashed the whirlwind and you will pay the price." And not a single Democrat senator had a word to say about this. And so their outrage is selective. And I will give my colleague from New Jersey a chance to just answer a simple yes-no question. Should the Biden Justice Department have enforced the criminal law against protesting at a justice's home? Yes or no?
So the rank hypocrisy of Chuck Schumer apologizing the next day and you holding that standard for him and not for your president, who you actually rightfully described when you were running against him in a primary. I would love to run those tapes of how you perfectly talked about the danger of our president and his rhetoric. But now you are failing, in fact, blind to the very things you're accusing Chuck Schumer of. I don't think Donald Trump would know an apology if it hit him in the head. Never has said apologizing. So again, you are very, very, sir, very, very deep into the waters of hypocrisy in your criticisms of Chuck Schumer.
So let the record reflect that Spartacus did not answer the question and did not tell us whether the criminal law should be enforced, because he knows the answer is yes, and he knows that the Biden Department of Justice was being wildly political and partisan in refusing to enforce the law because they disagreed with the Supreme Court justices' rulings. I have also, in addition to Senator Durbin, who's given his opening statement, I have a written opening statement from Chairman Grassley. Without objection, that written statement is entered into the record, and I will now briefly introduce our distinguished witnesses. We have three. Our first witness is Professor Josh Blackman, who holds the Centennial Chair of Constitutional Law at South Texas College of Law in my hometown of Houston, Texas, where he's been teaching since 2012. And although Professor Blackman was born and grew up in Staten Island, he got to Texas as fast as he could, and both of his daughters are proud native-born Texans, and I commend you for that. He is one of the country's leading voices on constitutional law. He has testified before Congress. He is a frequent voice in the New York Times, the Wall Street Journal, the Washington Post. He is, in 2024, was named the Jurist of the Year from the Texas Review of Law and Politics, an award that is near and dear to my heart since in a previous year I received the same award. And he is a senior editor of the Heritage Guide to the Constitution, 3rd edition. And he's authored 3 books, including An Introduction to Constitutional Law, which became a top 5 bestseller on Amazon. Our second witness is Professor Kate Shaw. Professor Shaw is a constitutional law scholar and professor of law at the University of Pennsylvania Carey School of Law. She joined the Penn Carey Law faculty in January 2024 from the Benjamin N. Cardozo School of Law, where she also served as co-director of the Florsheim Center for Constitutional Democracy. Her scholarship focuses on executive power, the law of democracy, the Supreme Court, and reproductive rights. She has also taught courses on administrative law and legislation, as well as a seminar on the U.S. Supreme Court. Before entering the academia, Professor Shaw served in the Obama White House counsel's office and clerked for U.S. Supreme Court Justice John Paul Stevens and Judge Richard Posner of the U.S. Court of Appeals for the 7th Circuit. Her academic writing has appeared in the Harvard Law Review, Columbia Law Review, Georgetown Law Journal, and other journals. She is married to Chris Hayes, a political commentator and host on MSNBC. And our third witness, Chairman Schmidt, will introduce, and if you can start the testimony, I've got to run to the floor and vote, and then I'll be back.
Okay. The third witness is Joel Alisea, and he's the inaugural St. Robert Bellarmine Professor of Law and Director of the Law School Center for the Constitution and the Catholic Intellectual Tradition. He has also served as a visiting professor at Duke Law School and Notre Dame Law School. Prior to joining the Catholic Law faculty, Professor Alisea practiced law for several years at the law firm of Cooper & Kirk, where he specialized in constitutional litigation. He previously served as a law clerk for Justice Samuel Alito on the U.S. Supreme Court and for Judge Dyermood and Judge O'Scanlan on the United States Court of Appeals for the 9th Circuit. Professor Alisea's scholarship has focused on constitutional theory, civil procedure, and constitutional law. He has been involved in the ongoing discussion on nationwide injunctions and the scope of the judicial power, both in the academy and in working with the Trump administration. And at this point, before you guys give your opening statements, it's a tradition of this committee to be sworn in. So if you'd please stand and raise your right hand. Do you swear that the testimony you're about to give to this committee is the truth, the whole truth, and nothing but the truth? So help you God. Thank you. Professor Blackman, we'll start with you.
Thank you. Chairman Cruz, Chairman Schmidt, Ranking Member Whitehouse, Ranking Member Welch, thank you so much for inviting me to testify. My name is Josh Blackman, and I'm the Centennial Chair of Constitutional Law at the South Texas College of Law, Houston. The topic of today's hearing is very timely. The supposedly least dangerous branch, district judges versus Trump. It is often repeated that we have 3 co-equal branches of government, but this isn't true. In Federal 78, Hamilton described the judiciary as the least dangerous branch. Unlike Congress, which is a power of the purse, and the president has the power of the sword, the courts have mere judgment. Yet it has been deeply ingrained in our consciousness that the court's foundational role is to balance the powers of the elected branches. Indeed, Chief Justice Roberts recently boasted that the courts check the excesses of Congress and the executive. But the Chief Justice is incorrect. Indeed, Vice President Vance recently explained that Roberts expressed a profoundly wrong sentiment. Or more local to me, Judge Ho in Houston aptly observed, It is not the role of the judiciary to check the excesses of the other branches any more than it's the judiciary's role to check the excesses of any other American citizen. So the question is, who will check the excesses of the executive? At least with regard to the lower courts, you all, Congress. The Constitution refers to the federal district courts as inferior courts. Yet far too many lower court judges seem to have a superiority complex. We're witnessing a never-ending onslaught of universal injunctions that make it nearly impossible for the executive branch to function. So what can be done? We can't look to the courts to check themselves. The long history of judicial supremacy teaches that judges of all stripes, conservative and progressive, seek to defend and entrench their own institution. The answer to any sustainable reform must come from the legislature. To paraphrase Madison in Federalist 51, legislative ambition must counteract judicial ambition. Yet regrettably, most debates about judicial reform get bogged down in politics. When there's a Republican president, Democrats love the universal injunction. When there's a Democratic president, Republicans love the universal injunction. It's predictable. Proposals that help only one side of the aisle have a slim chance of enactment. The federal courts cannot be reformed through unilateral disarmament. Any reform must be bilateral. I published an article called Bilateral Judicial Reform in the Texas A&M Journal of Law and Civil Governance. This was in 2024, before the election. And I got 10 ideas to fix the courts that might appeal to people on both sides of this aisle. I will talk about 3 of them in my limited time today. Number 1, cases seeking a temporary restraining order can be decided by a single judge, but can only give relief to the named parties and are limited to 7 days. No longer can a single judge issue a universal TRO that lasts for nearly a month without any appellate review. Second, cases seeking preliminary injunction or equivalent relief against the federal government and state governments are referred to the en banc court, which appoints a randomly drawn 3-judge panel with 2 circuit judges and 1 district court judge. There's some value in having a multi-member body consider an issue rather than a lone district court judge deciding difficult questions. And rather than having 2 district and 1 circuit, I prefer 2 circuit, 1 district, because these cases tend to focus more on law than on facts. The third proposal focuses on the appellate process. Chief Justice Roberts recently stated that the appropriate response to disagreement with the judge is the normal, he said, the normal appellate review process. As things stand now, the Supreme Court has a completely unpredictable and indeed arbitrary approach to emergency applications. I think we maybe all agree upon that. Congress can make the appellate review process of the Supreme Court normal again. Under my proposal, injunctions of statutes against the federal government and state governments are automatically stayed. The stay is automatic, it's not discretionary. And if a 3-judge panel submits what I call a certificate of division, that is, 2 judges go one way, the judges go the other way, the case is appealed to the Supreme Court's mandatory jurisdiction. They can't deny cert. And oral argument is decided on an emergency docket timeline, which Congress would then set. I think these 3 measures would have bipartisan appeal, which I hope they do, and will go a long way to addressing the never-ending fights between the president and the judiciary. Thank you so much, and I welcome all of your questions.
Thank you. Professor Shaw.
Good afternoon, chairs, ranking members, distinguished members of the subcommittees. Thank you for the invitation to testify today. I understand that the purpose of today's hearing is to discuss recent judicial rulings against the Trump administration and to situate those rulings in historical and institutional context. There is no question that the Trump administration has been on a losing streak in federal court. According to the most recent data compiled by Professor Steve Vladeck, district courts have ruled against the administration in 97 cases to date. That is a large number, but it is a number that is best understood in context. First, it has to be viewed in the context of the unprecedented volume of executive action we have seen from this administration. As of May 24th, the second Trump administration had issued 157 executive orders. By comparison, the Biden administration issued 162, nearly the same number, over the course of 4 years. The first Trump administration issued 220 over 4 years. It is not surprising that this much more executive action than previous administrations has drawn more challenges. The second thing to understand is that these rulings have come from judges who sit in district courts across the country and who were appointed by presidents of both parties. 25 district courts in 10 circuits and 73 judges appointed by 7 presidents have ruled against this administration. That leads me to my third point. These are not about policy disagreements. The reason there has been such wide and cross-ideological consensus over the impermissibility of the administration's actions is because the actions have been plainly unlawful, and that has been clear to jurists of all stripes. Again and again, the administration has acted in violation of both the constitutionally required process for lawmaking, one that gives Congress primacy, and the rights the Constitution commands government to respect. To be sure, some of these preliminary rulings against the government will be, and some have been, reversed or stayed on appeal. But it is telling that there are so many lower court losses that the administration has not even bothered to challenge. That is true in the birthright citizenship case currently pending in the Supreme Court, in which the lower courts have unanimously ruled against the administration. But the administration has not challenged those rulings on the merits. Instead, it has asked the court to use the case as an opportunity to restrict lower courts' ability to provide nationwide relief, and to do that in a context in which the administration is not even defending the lawfulness of its own executive order. Rather than focus on the appellate process or on remedying the legal defects that have been revealed by litigation, this administration and many supporters have suggested that the problem is district judges. The separation of powers is dynamic, it is not static, and there is definitely room for debate about the proper scope of both presidential and judicial power. At different moments in our history, different institutions and actors have sought to significantly increase their authority, sometimes in ways that could not be squared with the basic design of a constitution committed to limits on any single entity's power. At this moment, the entity engaging in overreach is the executive branch. This administration has been marked by a breathtaking degree of presidential unilateralism that is flatly inconsistent with statutes, the Constitution, and over 2 centuries of practice. For that reason, it would be profoundly misguided to seek now to curtail courts' authority by eliminating or seriously limiting their ability to issue nationwide injunctions. It is true that the use of such injunctions has increased in recent decades, and it is true that injunctions can be abused. But at this moment, courts are the only branch of government doing meaningful work to check the executive, protecting basic constitutional values, congressional prerogatives, and our liberty, which the separation of powers is designed to safeguard. If Congress does wish to wade into defending the separation of powers, I would suggest a couple of options. First, it could give the president some of the authorities he has tried to assert. If Congress agrees that the federal government should not protect Americans from abusive financial products and services, it can pass legislation doing away with the Consumer Financial Protection Bureau. If it wants to give DOJ access to Americans' sensitive personal information, it can repeal or amend the Privacy Act. If it wants the president to be able to impose sweeping tariffs based on his determinations of trade deficits, it can grant that statutory authority. As far as I know, it hasn't done any of that. Second, it could turn its attention to judicial security. Threats to the physical safety of federal judges have spiked in the last 4 months, and so have threats to judicial independence. There's a pending proposal that would move the U.S. Marshal Service from the executive branch to the judiciary in order to ensure that marshals are able to focus effectively on protecting federal judges and executing federal court orders. That would both comport with the original structure of the Marshal Service and would align the security practices of the judicial branch with those of Congress, right? Each branch protected by its own security apparatus, not subject to direct control by another branch. The federal courts are an important part of our constitutional scheme, and at their best, they can serve both to make rights meaningful and to enforce and facilitate core commitments to popular sovereignty and self-rule. They have not always done that, and again, a healthy democracy allows debates about the proper scope of judicial authority. But many attacks on the judiciary do not appear to be animated by a desire for good faith debates about the limits of constitutional authority. They seem instead of a piece with other efforts to neutralize any actor or institution that would seek to limit this president's power. Thank you again for the opportunity to testify, and I look forward to your questions.
Thank you, Professor Shaw. Professor Alicea.
Mr. Chairman, Ranking Member, members of the subcommittee, thank you for the invitation to testify today. It's an honor to speak with you. While the topic of today's hearing touches on many issues, my understanding is that I've been invited to address the practice of universal injunctions in particular, and that will be the focus of my testimony. An injunction is an order from a court directing an entity like a government official or a government agency to do something or refrain from doing something. Courts have been issuing injunctions for centuries, and when injunctions only grant relief to a party to the case, they're generally not controversial. What makes universal injunctions controversial is that they purport to give relief to entities that were never made parties to the case. In the birthright citizenship cases now before the court, for example, a district court judge in Seattle issued an injunction forbidding the enforcement or implementation of the president's executive order on a nationwide basis. That means that the executive order cannot be enforced against anyone, even though the only parties challenging the order were 4 states and 2 individuals. Now, universal injunctions are damaging to our political and legal system for many reasons. The effect of a universal injunction is that the policies of the elected president are subject to what is effectively a veto by unelected district court judges. Because it only takes a single judge to issue a universal injunction, the president's opponents only have to win 1 lawsuit to stop the president, whereas the president has to win every single lawsuit if he wants to implement his challenged policies. Because they place unelected district court judges in charge of national policy, universal injunctions are a problem for presidents of both parties. This is not a partisan issue. But universal injunctions have been used at an astonishing rate against President Trump in particular, which is why the issue has become so prominent over the last few months. For example, during the month of February alone, more universal injunctions were issued against President Trump's policies than in the first 3 years of the Biden administration. The result has been an atmosphere of continuous emergency throughout the first few months of President Trump's second term. It seems as if every time the president issues a new policy, it is almost immediately followed by a district court issuing a universal injunction. Since the president cannot allow a single judge to dictate national policy, the administration has had to seek emergency intervention by a court of appeals, and whichever party loses in the court of appeals then seeks emergency intervention by the Supreme Court. The court has therefore been inundated with almost nonstop emergency litigation, partly because of the practice of universal injunctions. The seemingly unending stream of emergency petitions has forced the court to make quick decisions on controversial and contested legal questions, often without the benefit of oral argument, adequate briefing, or different views expressed by the lower courts. This is not how our constitutional system was designed to work. Article 3, Section 1 of the Constitution vests the judicial power of the United States in the federal courts. As understood at the founding, the core meaning of the judicial power was the authority to resolve disputes between parties according to law. This party-centric understanding of judicial power explains why Article 3, Section 2 of the Constitution extends the judicial power only to cases or controversies, that is, disputes between parties. And that's why the Supreme Court has repeatedly held that parties do not have standing to seek relief beyond what is necessary to remedy the alleged harm to the plaintiff. Prior to 1789, injunctions were understood to be limited. An injunction could only provide whatever relief was necessary to redress a plaintiff's asserted injury. The same understanding of injunctions prevailed until the mid-20th century. Universal injunctions, it bears emphasizing, are a 20th century development, and their routine use against government action only began within the last decade. Thus, federal courts lack the power to grant equitable remedies that extend beyond what is necessary to redress the plaintiff's alleged harm, which is precisely what universal injunctions purport to do. The American people never gave judges the power to issue universal injunctions. Judges have seized that power for themselves, and only quite recently in our history. District court judges are thus exercising power for which they have no constitutional warrant. While universal injunctions have damaged the presidency and the Supreme Court, they have done the most damage to democratic governance by illegitimately thwarting the will of the people's elected representatives. As Justice Elena Kagan once observed, quote, "It just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process," unquote. Courts play a vital role in our constitutional system. They resolve disputes between parties according to law. And in the process of doing so, they say what the law is, as Chief Justice John Marshall said in Marbury v. Madison. None of that is at issue in the controversy over universal injunctions. What is at issue is whether courts can step beyond their limited role of resolving legal disagreements between parties and instead resolve policy disagreements for the whole nation. The answer to that question should be obvious: no.
Thank you to each of the witnesses for your testimony. Professor Blackman, prior to 1963, had any federal court issued a nationwide injunction blocking federal law or executive policy?
I'm not aware of any.
Would you agree that from the founding through the 20th century, the federal judiciary consistently understood its powers to be limited to the parties before the court?
Yes.
And would you agree that the widespread use of universal or nationwide injunctions, especially against presidential actions, is a recent development emerging in the last decade?
Yes.
That's important history, because what we're seeing now is not normal, and we have over 2 centuries of history when this didn't happen. It is instead a novel and dangerous concentration of judicial power. When a single district judge issues a nationwide injunction, are they acting as a constitutional judge or as a de facto national policymaker?
It's effectively a veto in the executive branch.
We've seen district judges block President Trump's policies on immigration, energy, birthright citizenship, and even federal hiring and firing, all prior to any appellate review, all without any input from Congress, all from one single judge. Let me offer an analogy. Suppose the federal government approves a plan to cut down trees in a national forest to make way for a pipeline. One person who occasionally camps in that forest files a lawsuit. The judge not only grants relief to that individual, but certifies a putative class action on behalf of all campers nationwide and issues an order blocking any tree cutting in any forest used by any member of the putative class across all 50 states. Professor Blackman, is that consistent with the Constitution's design for judicial relief?
No, it is not.
Or is that rather a recipe for nationwide paralysis based on a single courtroom?
Yes.
Would you also agree that the proper constitutional remedy is to address the plaintiff's actual injury, not to give one judge the power to halt activity unrelated to the case at hand?
Article 3 requires that.
And how does Article 3 require that?
Article 3 speaks of cases and controversies. As specific people have specific injuries. You cannot grant relief to broad classes who don't even assert an injury before the court.
And if broader relief is truly necessary, wouldn't that be better handled by class certification, by the appellate courts, or by Congress, not a lone district judge rewriting national policy?
Absolutely.
Can you explain how this pattern of nationwide relief not only intrudes on the president's Article 2 powers, but also undermines Congress's own lawmaking authority?
What ends up happening is you file many lawsuits in many districts seeking parallel relief, and it only takes one judge to grant the universal injunction. And once the judge grants the injunction, it's off to the races. Unless ruling stayed, the executive branch must immediately halt what it's doing. And this has really changed the way the executive branch and the courts have operated, as you said, over the past decade. And I think this time is ripe to actually address this issue and figure a way to stop this sort of insanity. We can't leave it to the Supreme Court to figure everything out.
And Professor Blackman, your testimony outlines structural reforms that Congress could enact to restore balance. Can you explain how requiring a 3-judge panel drawn from both district and circuit judges would deter judicial overreach and restore legitimacy to preliminary relief?
Well, this is how Congress ran things for much of the 20th century. They stopped in the 60s and 70s. The benefit of a 3-judge panel is you have diverse voices. In fact, even on this dais, you don't always agree with each other. But when you talk to each other, you find perhaps the closer truth. A single judge acting by himself or herself can often be like a god. There's no limitation on what they can do. But the benefit is if you have 2 circuit and 1 district, you're basically bypassing this next layer of review. Have the initial panel, 3 judges, and have managed review by the Supreme Court. We need to cut out this race to the Court of Appeals, this race to the Supreme Court. Let's compress the process and get to the result quickly enough so these issues of national significance are resolved fairly.
And by the way, if the characterization of these nationwide injunctions by my Democrat colleagues was accurate, if this was simply a result of, in their view, Trump's repeated lawless activities, one would assume a 3-judge panel would find the same ruling on the merits as a particular lone district judge. Is that correct?
In theory, but if drawn randomly, I think it's less likely. Random draws of 3-judge panels would be a very good change to see how things would work out.
Well, and much like Sherlock Holmes and the lesson he derived from the dog that did not bark, in this case, when we hear our Democrat colleagues talking about this is simply enforcing the law, the dog that isn't barking is why do they keep going to the same handful of radical judges in bright blue districts And why will every Democrat on this panel oppose any effort to require a 3-judge panel for a nationwide injunction? And the answer is they know fully well that a fair panel would reject the vast majority of these claims. And at the end of the day, I think too many Democrat members of this body want to frustrate the will of the voters who reelected President Trump and elected a Republican Senate and a Republican House, and they're perfectly happy for lone judges to impose their own policy preferences rather than respect the democratic will of the voters. Senator Whitehouse.
Thank you. It strikes me that what we have here is a team that has taken the field and engaged in unprecedented numbers of fouls and unprecedentedly flagrant fouls. And when the refs blow the whistle on the unprecedented number of fouls, the partisans of the team committing the fouls call out the referees for the unprecedented number of whistles that they blow. To try to level set this, let me ask if you can do a yes or no answer. Let's try to go right down the panel, yes or no. Is it appropriate to call judges USA-hating monsters who want our country to go to hell?
No.
No.
No, Senator.
In general, no, Senator.
And is it appropriate to call judges lunatics who do not care even a little bit and could very well lead to the destruction of our country?
I don't think so.
No.
No.
And is it appropriate to post pictures of judges' children with the intent to incite harassment and threats?
No.
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 Okay, good. We're off to a level set. I'll take that. Professor Alessia, when you were installed in your chair, the announcement was that the chair was made possible through the generosity of Leonard Leo, trustee of both the Marble Freedom Trust and Catholic University. Is that accurate? Is that who funded your chair?
My understanding is that Leonard Leo, through the Marble Freedom Trust, directed funds that funded the chair. I think that's accurate.
And with respect to your chair, Mr. Blackman, $1 million was given to fund it through an anonymizing organization called Donors Trust, which has been called the ATM of the far right. Do you know who was behind that Donors Trust laundered donation?
I appreciate the question, Senator. I would direct all these to my college to answer.
I'm sorry, first of all, your mic's not on.
No, I appreciate the question, Senator. I direct all these questions about this to my college. Thank you.
My question is actually to you, and it's whether you know. Do you know who was behind that donation?
I appreciate the question. Anonymous gifts are as they are, and I appreciate all those questions directed to my college.
Your college can't answer what you know. This is a question to you about what you know. This is a Josh Blackman question. Do you know who funded your chair?
I've answered the question.
Yes or no?
Thank you, Senator.
You can't say this. Do you realize that if you were an expert witness in a judicial proceeding, I'd be entitled to know who was funding you because it goes to bias and conflict, correct? That's basic sort of hornbook trial practice, right?
Fair enough, Senator.
I'm right about that. You'll agree.
We were invited to testify about nationwide injunction and the like. This is not something I was prepared to testify about, so that's my answer for today.
Okay. Well, at least we know who funded Professor Alessia, and you won't even answer what you know. Let me turn to Professor Shaw. Let's just say that this activity today is designed to whip up more animus against courts, and that it adds to the atmosphere of threats that the court is now experiencing. I think we're up to, is it 162 threats to judges, which is pretty impressive. And a lot of this has the appearance, at least to me, of looking like it was orchestrated, looking like it was instigated, looking like there are folks behind it. So presumably, the Marshal Service should be not just protecting the judges and their family members, but also investigating the sources of the threats. Can you tell us what some warning signs would be that the Marshal Service has been directed perhaps by the Attorney General or perhaps by some other senior official in the Department of Justice, to not do proper investigations, and particularly not look into orchestration or any effort to gin up these threats?
Senator, I have no information. It strikes me that a non-response to your queries or queries from other members of Congress to the Marshal Service or to the Department of Justice are concerning. There should be an active dialogue between the branches about something as serious as the security of the third branch. And I guess I would just echo what Senator Booker was saying earlier. I mean, there have been two relatively recent periods when bipartisan legislation was passed to improve judicial security after the tragic murder of Judge Salas's son and also after the attempted attack on Justice Kavanaugh. Judicial security measures on a bipartisan basis quickly passed Congress, and I would hope that this is a moment in which broad agreement could be reached that it's necessary to do something similar.
And if it appeared that those were part of a larger plan or conspiracy, it would be appropriate for law enforcement to look into the question of whether there was a larger plan or conspiracy, correct?
Absolutely.
Thank you.
I would note that Senator Whitehouse asked two of the three witnesses about private donations given to their respective law schools, but somehow omitted Professor Shaw. And I guess I would ask Professor Shaw, are you aware of what's been publicly reported in disclosures that your employer, the University of Pennsylvania, from 2013 to 2019 received from Communist China $67,618,610. Have you seen those public reports?
I'm sorry, Senator, I have not.
Well, they are publicly reported, and $67 million from Communist China. If we're going to just clarify the record, let's clarify the record across the board.
If I may, I actually don't hold an endowed chair, so I don't have an endowed chair personally, so I don't think I was being singled out for any reason, but that I don't have one.
Penn.
I do work for Penn, yes. Yep.
Chairman Schmidt.
Thank you. I suppose to further the analogy that Senator Whitehouse gave of reffing a game, I don't think anybody has a problem on this side of the aisle with a ref calling balls and strikes or calling a foul. The problem is, what if the ref's daughter hired the coach? What if the ref has money on the game? What if people start to question the legitimacy of the ref in the game? We all know what happens. People don't watch it anymore. Vegas takes the game off the board. So it gets to sort of this question of, as I referenced in my opening statement with Hamilton, the reason why it's supposed to be the least dangerous branch is it relies on the other two branches for enforcement. And the courts, the Article 3 branch, should be very well aware that if they lose legitimacy, they're cooked. And that's why we're having the hearing. Because people are questioning, how does Judge Boasberg, and I would actually ask you, Professor Blackman, pose this as a question. How in the world does Judge Boasberg get a case when he's not the emergency assignment judge, he's on vacation in the middle of the night? How can that happen?
I don't know, and perhaps even more significant, if you read the transcript of the case, he basically told the plaintiffs to change their case. They brought it one way. He says, no, here, plead it this way. Okay, good. Now I'm going to certify class and issue a ruling and go tell the plaintiffs around. He basically litigated the case on behalf of the parties. This wasn't merely a passive bystander. He was an active participant.
It's a statistic and possibility. And I want to I referenced what had been going on in the Eighth Circuit. 10 of the 11 appellate judges in the Eighth Circuit appointed by Republicans. Amazingly, Judge Kelly ends up on all the politically sensitive cases on a panel. It's not possible, except for the clerks there in that office, or the people that work for the clerk's office, are populated by her former clerks. So these are the kinds of things that this isn't just a new phenomenon. This is a concern about activism on the bench that's existed for a long time. It's just now on steroids. You talked briefly, and I mentioned it too, sort of Rule 23 as a more viable option for this, limiting limiting the orders to the parties, the rulings to the parties before the court as a case in controversy. Those are ways to address this. Are there any other structural suggestions that you have? And I also want to pose this to Professor Elisei as well.
Sure. I think one urgent need is to think about automatic stays. When you have district court judges granting universal injunctions and they don't stay their rulings, there's this frantic race to the Court of Appeals and to the Supreme Court, and the executive branch is not capable of actually changing policy on the fly, and that gives rise to these attempted contempt proceedings. I would think about if a universal injunction is granted or a nationwide class is granted, stay the ruling for 24 hours, 48 hours, some limited period till he's taken appeal to the appellate court, and don't let the judge just ruled against you decide whether appeals to be taken. I think the automatic stay will go a long way to addressing these issues.
Professor Alcea?
I think beyond Rule 23 and the enforcement of Rule 23, it's important to address the scope of injunctions not just through the non-APA route, but also through the administrative procedure route under Section 706. So I think that to the extent that we're going to really address the problem overall, you can't just address universal injunctions that are done outside of the context of administrative action, but also through the process that the APA sets up for challenging agency action.
Thank you. Professor Blackman, I do want to, you recently wrote an article in May of this year where you state the District of Maryland's standing order, that judge that automatically blocked deportations upon filing a habeas petition without merit review is pretty clearly designed to thwart the Trump administration's immigration policies. Could you explain that?
Yeah, this is unusual. So the District Court of Maryland issues what's called a standing order, which is basically an order that applies in all cases. And it says, by virtue of filing a habeas petition, a grant of stay is automatically issued. The Supreme Court has said there's a four-factor balancing test to decide whether a stay must be granted. This is automatic. Indeed, if you actually read this seriously, it's a permanent handcuff on the president's authority to deport people. The judge actually walked it back about a week ago. They sort of modified it. Maybe the Judicial Conference got wind of this. But I think there's still an attempt to limit the executive power in ways that have not been done before.
And it was issued to the government, I think it was writ large, right? I mean,
Yes.
This is very unusual.
Right. It wasn't notice given in each case. It was by virtue of posting on a website. This rule applies universally. There's actually a rule that says any ordinance you put on each ECF docket, it can't be done globally.
I think so one of the points of this hearing, the Supreme Court has a case in front of it where it has an opportunity to rein this in. And I think the Chief Justice is very keen to understand the perception of the court. It seems to be a good opportunity, I think, probably for the Supreme Court to finally weigh in here. Thank you. Senator Welch.
Just a couple of points I want to make. Number one, the effort to get universal injunctions has been pursued by litigants, including some of the attorney generals who serve on this committee. I know you did, as Attorney General, got several sought several universal injunctions.
Since you referenced the vast censorship enterprise of the Biden administration that a court declared was perhaps the biggest offense to the First Amendment in the history of the country, where there were named parties that were specifically enjoined, you mean that case?
Yeah, I do. My point here is that if there's an opportunity out there for a litigant, whether it's a lawyer trying to get the judge that he or she thinks is going to be the most favorable, or an attorney general trying to get the most relief for something that he or she believes in, they'll do it. So it's up to us if we think that process should be adjusted to change it. But it's not a Republican-Democratic deal. I mean, it's what litigants do. The second thing is, Professor Blackman, you mentioned how some of these universal injunctions inhibit the authority of the executive, right? What's the problem with that? I mean, what's so great about the executive having unlimited authority?
Well, I'll take the Alien Enemies Act in particular. This is a statute that's been around for 200 years. It's been enforced in various times. And historically, it's been a very deferential statute. The courts haven't scrutinized when it should be enforced, and they haven't told plaintiffs to turn around. So I think we're seeing not only aggressive use of the universal injunction, but also intrusions upon the executive authority.
So I get that. And let me just be clear. I disagree with you. And I disagree with the executive invoking what I regard as a very discredited law and using it to deny due process. So I'm on the side of pushing back against executive authority. So I don't see that as a big problem. Professor Shaw, one of the things people here are talking about is the class action. Mm-hmm. And here's my question with it, and I want you to address this. I had a small town law firm, and I'd have people who walk in, and every once in a while, they had a hopeless case that we'd take, and we'd get them relief. And if I had to do that in a four-person law firm and certify a class action, I couldn't have taken that case. So this so-called remedy of using the class action means that those Vermonters or those folks in Washington State or wherever who go into a lawyer's office to seek relief and that lawyer's willing to take the case, what are the burdens on that law firm if they have to certify it as a class?
Yeah, I mean, it seems to me that, let's take maybe the birthright citizenship example, arguments that challenges can be maintained against this executive order, but they have to be done using the class action device. I'm not sure if those are being made in good faith. Rule 23 of the Federal Rules of Civil Procedure has relatively demanding requirements. The Supreme Court has ratcheted up those requirements in a series of cases in the 2010s. The plaintiffs have to be similarly situated in terms of their injury and the kinds of relief that they are seeking. And the Solicitor General in the Supreme Court a couple of weeks ago didn't disclaim the likelihood that they would be back before the Supreme Court saying, well, you shouldn't even be able to certify a class with respect to this executive order. So it feels to me like a little bit of a heads we win, tails you lose. You can try a class action and we will marshal different kinds of arguments against you doing that, but it is not as though it is very easy to satisfy the requirements of Rule 23, and I think that shifting from these injunctions to a pure Rule 23-based regime would disadvantage those unable to secure representation, who don't satisfy the requirements of class membership, and would mean no relief from government unlawful conduct.
Yeah, and that's one of the things that's so important, hopefully to all of us, is access to the courts for an everyday person in Missouri or Texas or whatever. So you get some lawyers who are just willing to do it because it's a neighbor, it's a friend, it's a cause they believe in. I want them to be able to act and bring that case to court and not have to go through the incredible expense. On the question of universal injunctions, I mean, are there some suggestions you have or forum shopping that you have that would expedite or address what you perceive to be some legitimate problems that aren't siding with the partisan divide on this question?
Yeah. Thank you for that question, Senator. I do think that single judge divisions, which allow plaintiffs to, with absolute certainty, ensure that they will receive a particular judge when they file in a particular division of a district, are an enormous problem, right? That forum shopping is not exclusive to these single judge divisions, but it is the most serious kind of forum shopping. And I should say, as of, I think right now, none of the orders against the Trump administration have issued from judges who sit in single judge divisions, unlike some of the orders issued against the Biden administration. But I do think that the Judicial Conference has already endorsed a proposal that would essentially eliminate these single judge divisions. I think that's something that we should all be able to get behind.
Thanks. Well, I'd be willing to work with my colleagues on some of these practical questions and practical answers where we strip out whether we agree or disagree with the particular decision that's been made by the court. Thank you. Thank you all.
Professor Shaw, you said Congress had set high standards in Rule 23 for certifying class actions. Why would we have set high standards for class actions?
So I don't think I said that, sir. Just that the Rule 23 standards are relatively demanding, that the court has ratcheted up the difficulty of satisfying them.
So, but why would we set demanding standards for class actions?
I'm not sure. The Rules Committee produces the rules, so I'm not quite sure.
But Congress adopts them.
Yes. So, I mean, you tell me, sir.
Well, there's a reason we have high standards for class actions, because it should be difficult to certify a nationwide class, and what we are seeing is single judges ignoring the federal rules of civil procedure, ignoring the rules Congress has set out for class certification, and saying, I'm just going to issue an injunction to the whole damn country, and it doesn't matter if it meets even the bare thresholds of the federal rules. Senator Kennedy.
Would any of you advise a client to defy a federal court order?
No.
None of you would? How about you, Professor?
I mean, under most circumstances, we follow the government and private parties follow court orders. I suppose it's not, I would not rule out ever the possibility that in a sufficiently egregious order, there should be some consideration of whether there's a way.
So in some cases,
I think it's a qualified answer, yes.
in some cases you would.
In an extremely narrow band of cases, I think it would be considered, yes.
Okay. Do any of you think that nationwide or universal injunctions are not being abused?
I'm not sure what if I may, Senator, I'm not sure what the time horizon of the question is. I don't think that there could be good faith disagreements about the correctness of some of them, but I have not seen in the last 4 months
Professor, you're
abuse.
smart,
No.
I've read your stuff, and I've read your writings. I don't want to get bogged down with this, but I have little respect for your opinion because I've read your stuff. When someone is in the White House that you agree with, and someone gets a universal injunction against him, you don't like universal injunctions. You called them judges acting like they're politicians in robes and judges looking like crass political actors. But now that President Trump's in the White House, who you dislike, you think that universal injunctions taste like pumpkin pie. So I have to discount what you say because I think you act on your political beliefs. And I worry that that's what you're teaching your kids. So I'll leave you out of that. Do you think nationwide injunctions are being abused?
Certainly, Senator. I think that is.
They're being abused by both sides, aren't they?
Yes, Senator.
Both Republicans and Democrats are forum shopping, aren't they?
Certainly.
Professor, do you disagree with that?
I think both sides are abusing them. I agree.
Okay. Both sides.
Yeah.
There are no clean hands here. Now, your suggestion is that when a federal judge issues a nationwide injunction, there should be an automatic stay and an expedited right of appeal. Is that right?
Yes, sir.
Do you disagree with that?
I haven't given enough thought to have a position on it, Senator.
I suspect, Professor, your answer will be it depends on who's president.
No, Senator.
Let me ask you about this. What if we had a rule? I was reading an article the other day. I'm not suggesting it. I just want your opinions. That said, if a president, any president, issues an executive order, let's say, that clearly violates settled Supreme Court precedent, that a federal judge can't issue a nationwide injunction. For example, if a president issued an order that said no one in America has right to counsel any longer, including but not limited to, in a felony case, having the government pay for your lawyer if you can't afford it. That clearly violates settled Gideon v. Wainwright. In that case, a judge has no authority or does have authority to issue a nationwide injunction. But in a case where the law is unclear, a judge should refrain from that. Now, obviously, we'd have to trust our judges, but we're supposed to be able to trust them anyway. What do you think about that?
I don't agree with that, Senator, because I think universal injunctions transgress the limitations under Article 3, even if the underlying merits are clear.
I happen to agree with you. I don't think there's any basis under Article 3, under Supreme Court precedent, under the English common law for nationwide injunctions. I think politicians have helped judges, and many judges are politicians, to just make it up. And many of them are like Professor Shaw here. If they like the president, they're against nationwide injunctions. If they don't like the president, they're for him. Professor, let me ask you this while I have you. On April 22nd, 2024, you said there are some members of the Supreme Court that are evil. Which justices were you talking about?
I'll take it your word, Senator. I don't recall using that word, but.
All right, here's what you said. You were talking about the majority opinion in Muldrow v. City of St. Louis. You said, quote, Justice Kagan, will she be able to control the opinion's future distortion by her evil colleagues? Probably not, end quote. Who are you talking about?
Sir, I'm very skeptical. If there's a transcription, it was probably a transcription error. I do not think I said.
No, you said it. Why don't you own up to it? Which you call some of the members of the Supreme Court evil. Now, which ones do you think are evil?
I would have to refresh my recollection. I've been very critical
You're
of some
embarrassed
members of the
that
Supreme
you made
Court.
that statement, aren't you?
I'm
You're an
telling
officer
Senator, it
of the
doesn't sound
court.
like something that
You know
I
what
would
I'm
say.
embarrassed at? That you're teaching our kids.
I don't refer to Supreme Court justices as evil
You did,
in
here,
the classroom,
on
sir.
your podcast, April 22nd, 2024.
Okay, well,
Big as Dallas. And you're an officer of the court, and you're here advising us to be respectful to federal judges, and you say they're evil members of the United States Supreme Court? Gag me with a spoon. You're part of what's the problem in all of this.
Thank you, Senator Kennedy. Senator Durbin.
So I'm going to give the panel members an opportunity to respond to a question posed by Justice Sotomayor during the oral arguments on the birthright citizenship bill. And she said, I'm paraphrasing, imagine a new president takes office and decides, because of the epidemic of gun violence in our country, to issue an executive order announcing that he will deploy the military to seize the guns of every gun owner across the country. That executive order would be swiftly challenged in a federal district court, or more likely in several district courts. Should a district court be allowed to issue a nationwide injunction to at least temporarily prevent the enforcement of that executive order? I'd like each of you to respond. Professor Blackman.
I actually addressed that point in the blog post. We actually have history of someone in this country disarming everyone. His name was General Gage, and that was not fought with Rule 23.
So your answer?
I don't. If the president came to take everyone's gun in this country, I don't think the remedy would be in the courts.
Professor Shaw?
Yes, I mean, I think that whatever the constitutional right is, whether it's a Second Amendment, a First Amendment, a due process right, if a president tries to do something that is in clear violation of settled law, whether we like the law or not, that an injunction is an appropriate remedy.
Professor Alessia?
No, Senator. I've written in support of the Second Amendment in many fora, but I don't think that a judge could issue a universal injunction under those circumstances. Of course, the challengers could seek certification under Rule 23 and then try to pursue class-wide relief.
So do you think it's reasonable to expect every single person affected by an executive order like the one I described to seek relief through Rule 23, or to file their own lawsuit to seek relief?
I don't think that would be necessary, Senator. If you had one person who sought class certification successfully, that would be sufficient. But even if you had failures to class certification, once you get to the Supreme Court and the Supreme Court issues a binding decision, that precedent would bind all the lower courts. So it's not a question of whether you get to a uniform rule, it's just a question of when you get to a uniform rule and by what route. But those limitations on the route matter under Article 3.
There's been a lot said during the course of this hearing about the possibility or likelihood that judges are being selected for this process to review the decisions of the Trump administration on a political basis. Professor Shaw, I noted, I'm not sure you read this into the record, but you said according to a recent analysis by Professor Bonica, the Trump administration has lost 80.4% of the time before district judges appointed by Democratic presidents, 80.4 Democrats, 72.2 before district judges appointed by Republican presidents. Who is Professor Bonica?
He's a political scientist at Stanford, and so that's in my written statement. And I think it does suggest that it cannot be reasonably just attributed to policy antipathy. This is about a pretty broad consensus about the lawlessness of many of the administration's actions, and I think both Democratic and Republican appointees have seen that.
That's my impression as well. This is not a stacked deck, a statistical impossibility. It is a fact. This president has issued more orders with more controversy than any president in recent memory. I have only been to Amarillo once when I was a younger person, I'm sure it's a lovely city. But it turns out that the Amarillo Division of the Northern District of Texas has gotten quite a bit of publicity. It turns out that there are people have been filing lawsuits there because there's only one judge who sits in that division, Judge Matthew Kaczmarek, who I remember appeared before the committee. Litigants knew Judge Kaczmarek would be assigned to their cases and viewed him as favorable to their arguments. So the argument that's being made that venues shopping, forum shopping, is on one side of the table. It is clearly on both sides of the table, and Judge Kaczmarek is pretty well known for the way he rules. Professor Shaw, if you have any observation on that?
Yeah, I mean, as I said in response to Senator Welch, I actually think that those single judge divisions, like the one in Amarillo, Texas, where Judge Kaczmarek sits, are a genuine problem. But none of the injunctions against the Trump administration have issued from judges who sit in those single member districts. So I'm not even sure it's fair to say that that's a problem we are seeing now and we saw previously. We actually aren't seeing it now. But I do think that regardless of who the president is, these single judge divisions are a problem that Congress would be well served to address.
Thank you very much. Thank you.
Thank you. Senator Hawley.
Thank you very much, Mr. Chairman. Mr. Chairman, it's great to have this hearing. Thanks for calling it. Thanks to all of our witnesses for being here. Professor Shaw, nice to see you again. Let me just start with you, if I could, Professor Shaw. You talked about the fact that there have been lots of rulings against the Trump administration. That's absolutely statistically true. I disagree with almost all of them. In fact, I think all of them. But the issue of this hearing really isn't the rulings, is it? It's the remedies. Would you agree? And those are distinct things. You may think that the ruling is quite correct, but that's actually not what we're talking about here today. We could have a hearing on that. Maybe we should. But we're talking today about the remedy. And the question is a remedy that binds parties who are not before the court, is that an appropriate thing? I mean, aren't you concerned about judges binding non-parties in their remedies? You may love the ruling, but even if you do, don't you think it's a little bit anomalous for courts to be going out there and binding parties who are not before them? I mean, is that something we want to encourage?
Senator, I think that judges have been issuing rulings that impact non-parties since Marbury versus Madison, right?
So you're not concerned about it?
I'm not. I absolutely think that they can be abused, and
well,
they
no,
have been abused.
Wait a minute. You were very concerned about it just a couple of years ago. Yeah. You said in response to a nationwide injunction on the Biden FDA's mifepristone rules, and I quote, "This injunction's a travesty for principles of democracy, notions of judicial impartiality, and the rule of law."
I think I've been consistent today. That was issued by Judge Kaczmarek in a single judge division. They're a problem. Those are a problem.
With him personally? Wait,
no.
So your testimony is if it's issued by Judge Kaczmarek, it's bad?
No, sir.
It's personal?
That is not my testimony.
Is the problem with the injunction? You were criticizing the universal injunction
issued by a judge in a single judge division. I've been very clear today that those are a problem.
By a Republican judge in a Republican division, then it's bad.
No, Senator.
Otherwise, it's fine.
No, Senator. I think that single judge divisions are a problem.
What is the principal difference? I'm looking for a principle. I understand you hate the president. I understand you love all of these rulings against him. You and I both know that's not a principle. You're a lawyer. What's the principle that divides when issuing a nationwide injunction is okay when it's not? When the Biden administration was subject to nationwide injunctions, you said that they were travesties for the principle of democracy. You didn't say the referral to Judge Kaczmarek was a travesty. You said his injunction was a travesty for principles of democracy. Yeah. So, in other words, the translation is just you didn't like the outcome. Is that right?
No, Senator. Look, we're talking about, I don't think Article 3 precludes this form of relief. So we are talking about prudential considerations.
Prudential meaning political?
No.
Then give me, so far I have yet to hear it. You've been questioned by multiple senators. I have yet to hear a principle other than the fact when you like the ruling, you think it's great to apply it nationally, including non-parties. When you don't like the ruling, it is a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law.
Look, Senator, I'll say I think I am self-aware enough to know that my view of the underlying legal question, I am sure colors my perception of the remedy. I think that we should all acknowledge that. And yet I do think
and why shouldn't we stop nationwide injunctions for everybody?
I think that's
what we're talking about today.
Because I'm not willing to leave without relief non-parties who are
injured.
No,
you're not willing to leave without the ability to bind President Trump.
No, I
right?
think that...
I mean, when it's Biden, it's okay. No. When it's Biden, it's a travesty. When it's Trump in office, it's no holds barred, whatever it takes, right?
I believe in a powerful...
What was it that President Biden's staff said? We've got to do undemocratic, unconstitutional things to save democracy. Why is this the same
I believe
thing?
in a powerful president. I do believe in presidential power, but power and constraint are not at fundamental odds.
What
Constraint
is the
legitimates
principle?
power.
What is the principle? The legal principle. You've referenced prudence. You've referenced the judges you don't like. What's the principle of when an injunction binding non-parties, which was never done in this country before the 1960s? And let's see the chart, the Trump chart, which was done really only once Trump came into office for the first time. You don't think this is a little bit anomalous? You don't think that's a little bit
A
strange? Do
very
you think this is
plausible
good for the rule of
explanation,
law?
Senator, you have to consider is that he is engaged in much more lawless activity than other presidents, right?
You don't think
you must
this
concede that
was
as a
never
possibility.
used before the 1960s, and suddenly Democrat judges decide we love the nationwide injunction, and then when Biden comes to office, no, actually.
It's Republican appointees as well, Senator.
don't like
And the 1960s is where some scholars sort of locate the beginning
Can you
of this. But
identify one
others,
before then?
Mila Sahoni, who's another scholar of universal injunction, suggests 1913 is actually the first. There were others in the
so we
20s.
endured, the Republic endured for 150 years before there was a nationwide injunction.
Well, the federal government was doing a lot less until 100 years ago. So there's many things that have changed in the last 100 or the last 50 years.
So long as it is a Democrat president in office, then we should have no nationwide injunctions. If it's a Republican president, then this is absolutely fine, warranted, and called for. How can our system of law survive on those principles, Professor?
I think a system in which there are
Is
no
that
meaningful
blind?
constraints on the president is a very dangerous system
That's
of law.
not what
and
you thought when Joe Biden. That is not what you thought when
I
Joe
think
Biden was
every
president.
president
You
is
said that is
constrained
not what
and
you
must be.
said. You said it was
Absolutely.
a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law. You also said
Supreme
when Joe
Court, Senator,
Biden was
agreed
president. Wait a minute.
9-0 with me on
you
that
also
case,
said
to
when
be
Joe
clear.
Biden was president, you said the idea that anyone would foreign shop to get a judge who would issue a nationwide injunction was just politicians, just judges looking like politicians in robes. Again, it threatened the underlying legal system. People just trying to get the result they wanted. It was a travesty for the rule of law. But you're fine with all of that if it's getting the result that you want.
Sir, the Supreme Court agreed unanimously with me in that case, right? There was no standing. The case should never have been allowed to proceed.
Wait,
and the
what
combination of
case?
parties without standing and the single-judge division.
No. We're talking. No, they did not. They did not issue a ruling on the nationwide injunction. You criticized the injunction nationwide. Listen,
Issued in a
we
case
can
where
go
no
round
one
and
had
round on this.
standing.
Here's the thing. We've now gone 6 minutes, and Senator Kennedy had you for 6 or 7. You couldn't identify a single principled basis. We all know the truth here, which is it's not just you. It's most of my colleagues over here on this side of the aisle, who I respect a great deal, and they were raising very principled objections to the nationwide injunction just 6 months ago, maybe 9 now. And you're probably right. My point is that all that's changed in 9 months is the occupant of 1600 Pennsylvania Avenue. And I realize that my colleagues on this side of the aisle very much dislike that individual, and I realize that you think that the rulings that he has lost are fundamentally sound. We might grant all of that. I disagree with all of that, but we can put that to one side. The question we're talking about here is, should judges, single judges, district court judges, be able to bind non-parties who are not in front of them? And you used to say no, now you say yes. Let's be consistent. I would just suggest to you our system of government cannot survive if it's going to be politics all the way down. Thank you, Mr. Chairman.
Can I briefly respond?
Sure.
I mean, you invoked democracy a couple of times there, Senator. Judges are part of our system of democracy. Democracy is not as simple as majority rule. Judges have always served something of a
You would have it be as simple as
function.
majority rule. When you get the majority you like, you're for the nationwide injunction. When you don't, you're not.
Senator Blumenthal.
Thank you, Mr. Chairman. I'm going to give you the opportunity that I often found absolutely precious when I was arguing before a panel of judges and couldn't get my answer out. I'm going to give you some of my time to just say what you were going to say to Senator Hawley.
Thank you, Senator.
I can't interrupt you.
Okay, thank you, Senator.
I'll take some of your time.
I started to say this.
By the way, we're good friends, so it's not personal.
Well, maybe I'll just finish what I started saying at the end, which is in a number of the questions today, there has been this embedded premise that there's something democratically troubling about judges issuing these nationwide injunctions, constraining the democratically elected president. And I guess I would just say in response that, we have a constitutional democracy, so the people are sovereign, and that's, that sovereignty flows from the people, and we do choose our elected representatives, but obviously we choose our representatives in Congress. Congress passes statutes, the president signs them, and many of the rulings we are talking about were predicated on executive branch violations of statutes that Congress passed. So the rulings in many ways are about protecting and reinforcing democracy. And then finally, I'll say that, courts are part of our democracy, right? They have served this rights protecting and democracy facilitating function from basically the beginning, whatever the original design of the Constitution was. And it is not undemocratic or anomalous for courts to sometimes strike down acts of the president or of Congress when they conflict with the fundamental law, which is the Constitution, which in our system, courts have long had the primary role in enforcing.
And in fact, just as a footnote to this conversation, Congress has an obligation to follow the Constitution too, correct?
Absolutely. The president does, Congress does, every official, state and federal takes an oath to uphold the Constitution, but where that oath does not appear to be fully honored by one or more other actors in government. Sometimes courts do need to step into the breach. I think that is what we have been seeing.
And I can't remember exactly what that chart said, but so far in the lawsuits that have been brought, the administration or the president has lost, I would say, a vast majority of times. Is that correct?
The vast majority, yes, Senator.
And I want to ask a somewhat open-ended question because I have to confess, as Attorney General of the state of Connecticut, I probably succeeded, I can't name in which cases, obtaining a nationwide injunction. Then Attorney General Schmidt sought more than...
You started it. Is that your admission?
sought more than a dozen nationwide injunctions against the Biden administration. Then Attorney General Moody also sought numerous nationwide injunctions. This is a tactic, and it's a well-founded one, that attorneys general, litigants, and others have used again and again and again. And it shouldn't be a partisan issue. Nationwide injunctions shouldn't be a partisan issue. And when I say they did it, I'm not being accusatory. I confess I did it. And I don't know about then Attorney General Whitehouse. He can speak for himself, but it should not be a partisan issue, should it?
I agree that it shouldn't be, but of course, yes, it has been. I mean, I think that despite the somewhat heated exchange I was just having with Senator Hawley, I do think that we don't want judges to be sort of driving the train of policymaking, and there are absolutely, there may be points and there may be contexts in which it does feel as though some fundamental change to the way judges consider nationwide injunctions, how much there's some critique that the merits have become the entire analysis and that there should be some prescriptions that are different about the kinds of harms that should be, the way harm should be evaluated or assessed. So I do think there are, again, back to the sort of prudential point, there are absolutely reforms that I think that there could be some...
Just to take, and I apologize for interrupting, but I am running out of time.
Yeah, sorry.
To take Senator Hawley's point about looking for a principle, a jurisprudential lodestar here, maybe we do need some refinement on a bipartisan basis to provide some guidelines to district court judges, some of whom come to work on their first day and are presented with litigation that determines whether or not kids get health care or whatever in parts of the country they've never visited, in towns they don't even know how to pronounce.
Right. So, and whether that comes from a rule change, Supreme Court guidance, something legislative, I am not sure, but I think there could well be bipartisan consensus around clearer standards that guide judges asked to consider requests for nationwide injunctions.
And that would probably increase the credibility of what courts do if they could point to standards that were not just personal preferences or whims or, perhaps subconscious political leanings.
I agree with that, Senator.
Thank you. Thanks, Mr. Chair.
Thank you. Senator Blackburn.
Thank you, Mr. Chairman. Professor, I do want to come to you, and I want to return to the conversation about calling the Supreme Court justices evil. You host a podcast, correct?
Yes, Senator.
And that is called Strict Scrutiny, correct?
Yes, Senator.
Okay. You made those comments on your podcast. And Mr. Chairman, I would like to submit the recording of that podcast for the record.
Without objection.
Thank you, Mr. Chairman. In that podcast, you referenced, as Senator Kennedy said, to Justice Kagan an opinion, and you referred to the conservative justices as, and I'm quoting you, her evil colleagues. That is something you said on Strict Scrutiny in your podcast. And you, in that same podcast, you made a reference to Justice Alito. Do you recall that?
I don't recall that. We certainly do reference Justice Alito, so I believe that, but I don't recall specifically
your comment
what.
There was that he was an abject misogynist. So, since this is your podcast that you hosted, and this was your opinion on that podcast, would you like to provide explanation about why you think conservative justices are evil and why you would think Justice Alito was a misogynist? Do you care to explain yourself?
I would have to look at the transcript, Senator. I think that the dismissive approach to sex equality arguments in the Dobbs case was deeply concerning. One paragraph in the opinion suggests that there's no sex equality problem with abortion restrictions or prohibitions. I think that's deeply wrong. And in the more colloquial sort of mode of a podcast conversation, that is probably what I intended to convey, that he discounted very serious sex equality concerns.
You were angry and you let your emotions get the best of you, is basically what you're saying.
I don't think I'm saying that, Senator. I was having a conversation, and I am sure I was criticizing Justice Alito. We frequently do on my podcast.
Okay. Would you call that lack of respect?
As in the context of a podcast, we frequently, I will stipulate that we frequently demonstrate a lack of respect for writings of the Supreme Court justices.
That is good to hear that from you, that you have that admission of guilt. So thank you for that. I've got a question for the entire panel. There was discussion about Section 1507 and protesting outside of judges' residences, justices' residence. And I've got a bill, the Protecting Our Supreme Court Justices Act, and it would deter intimidation of Supreme Court justices. And in the exchange Senator Cruz had earlier, he referenced that purposeful intimidation. This would change, it would increase the maximum term of imprisonment for violation of Section 1507 from 1 year to 5 years, and increasing the maximum time, jail time for a protester under 1507 is, I think, an effective way to deter this intimidation of our justices. So I'd like to hear from each of you on this. Professor Blackman, I'm going to come to you first, and then just a very quick, short answer from each of you.
Sure. I think it's a good idea, and I think it should be enforced vigorously as well. We mentioned Judge Kaczmarek before. He's had several death threats against him. They resulted in plea bargains. So I think there's a serious problem that needs to be addressed with enforcement.
Okay. Professor Shaw?
You know, I think that any law that also touches protected First Amendment conduct would need to be scrutinized carefully, so I would need to take a look. I'm not prepared to take a position here.
Outside of a...
No, this is about protest outside of... Protests or
intimidation.
Okay, so violence, absolutely. I mean, if we're talking about increasing penalties for violence, I would absolutely support that, yes.
Okay, great. Professor?
I certainly think we need to carefully scrutinize the level of violence and the threats against Supreme Court justices and other judges, as we saw when there was a threat against Justice Kavanaugh's life, right, an attempted threat against him and his family. So it underscores the seriousness of the issue, and I think it's important for Congress to take a look at this.
Thank you. Thank you, Mr. Chairman.
Thank you. Senator Hirono.
Thank you, Mr. Chairman. I kept hearing one of my colleagues accusing you, Professor Shaw, of disliking nationwide injunctions only when it is applied to Democratic presidents. He tried so many times. That is not what you said. That is certainly not what I heard. What I heard you say was in those instances where there's a single judge in a district, that can lead to foreign shopping, judge shopping, which is exactly what happened in Amarillo, Texas. And you said that is something that Congress could address. I think that is a fair depiction of what you testified to. Is that correct?
Thank you, Senator. Yeah, that was in my written testimony, and I think that I did confirm it today.
So I had introduced a bill to Stop Judge Shopping Act, which would require suits seeking nationwide relief against the enforcement of federal law to be filed in the D.C. District Court. And I explained at the time that I introduced the bill that this court, quote, hears the large majority of cases involving challenges to federal agency action, and its judges are experts at deciding these cases impartially, end quote. That is one of the ways that we can address the issue of foreign or judge shopping, which you did address once again today. Correct?
Yes, Senator.
Yeah, I wish we could take that bill up. So, this attempt of my colleagues to continually attack the Democrats as somehow not wanting judges who decide cases based on objective facts, application of the law, as opposed to having some kind of ideological axe to grind is really more something that they have a problem with, apparently, than anything that we Democrats stand for. Once again, Professor Shaw, there was a suggestion today that case assignments in D.C. is happening in a way that is statistically impossible. And I think this only serves to point out that maybe the person who made this allegation doesn't have enough awareness of statistics or hasn't read the rules in the way cases are assigned in D.C. Do you have any response to the allegation that someone is stacking the decks against the Trump administration in this court, in the D.C. District Court?
Right, Senator. So I've heard both that critique that Judge Boasberg is getting a disproportionate share of the cases and also the kind of opposite critique that the motions panels in the D.C. Circuit have been more favorable to the Trump administration than random chance would produce. Statistically unlikely events do sometimes occur, and I think it very unlikely that there is anything untoward resulting in the assignments either at the district court or the Court of Appeals level here in D.C.
I have to thank you for pointing out how many cases. There have been over 200 cases filed to stop this president from, in my view, abusing his power and engaging in illegal acts. And frankly, and I think Mr. Blackman also suggested this, as did you, Ms. Shaw, that if we don't like this president to be sued, then we in Congress should enact laws that allows him to do whatever the hell he wants. So why don't we let him ignore the appropriations of this Congress? Why don't we let him stop certain grants from being issued? Why don't we let him go after Harvard and any other school that he doesn't like? Why don't we let him go after law firms that take positions that he doesn't like? Why don't we let him do that if we don't want him to get sued? I think that's a rhetorical question, but certainly we could do that. Thank you, Mr. Chairman.
Thank you. Senator Schiff.
Thank you, Mr. Chairman. Ms. Shaw, I wanted to ask you about some of the threats we're seeing on the judiciary, but let me preface it by quoting the president, who has called federal judges who rule against him communists. He's called them lunatics. He's called them monsters. He has said that they hate the United States. Of course, he called for the impeachment of Judge Boasberg, said the court system is radicalized and incompetent. His advisor, Stephen Miller, has threatened to suspend the writ of habeas corpus if judges essentially don't fall in line. And as a result, we're seeing judges' lives threatened and their family members' lives threatened. Let me start with a threshold question in terms of a president making these personal attacks on judges for ruling against him, or the policies, against the policies of the administration. Have we any experience in our history with this? I mean, there have been presidents, of course, who've been deeply disappointed in judges they've appointed, and of course, many of these judges ruling against Donald Trump were people appointed by Donald Trump. But have we ever seen a president make these kind of sustained and personal attacks on members of the judiciary?
Senator, look, I would say that obviously tension between, sometimes very heated tension between elected officials and judges, presidents and judges who rule against them is nothing new. But I agree with you that there is something different about the tenor of the rhetoric that we are hearing today. And I think that some of the specific suggestions, and maybe I'll offer a couple of examples. One, I do think that including family members of judges in the attacks on judges' rulings is something that, to my knowledge, we have not previously seen members of public office engage in. The proposals to impeach, right? So there's been rhetoric, but also actual resolutions introduced in the House to impeach federal judges for the substance of their rulings is also something that I don't think we've seen. We've obviously impeached federal judges before. That's a constitutional remedy for very serious misconduct, bribery, corruption. Obviously, if the judges engage in treason, bribery, and other high crimes and misdemeanors, impeachment is the remedy. But we've never seriously entertained the possibility of impeaching judges for the substance of their rulings. And so I do think that those threats represent sort of a new escalation that is deeply concerning.
Well, I would certainly agree. I tried one of those judicial impeachment cases of a judge named Porteous, and it was for bribery and other like serious offenses. Certainly not for upholding the law or the Constitution or having a different view of the law or Constitution than a president. In terms of the family members, it's not just the president's criticism, but at least while he was serving as a special employee, Elon Musk was pushing out these threats against members of the Judge Boasberg's family, I think tweeting out or retweeting content identifying who the children are or where they work. And that is just amplifying the danger to these family members. Tell us a little bit about this phenomenon now of people sending pizzas to judges and the implicit threat in that.
Well, I mean, I think it's this is also something that I don't think we have seen before, right? There is clearly some kind of coordinated effort to seek to intimidate federal judges and their families by sending pizzas, communicating the message that their residence, their addresses are known, and some of the pizzas bear the name of the murdered son of District Judge Esther Salas from New Jersey. And the message there, I think, is a very clear one of very serious threat, and I think judges are taking that threat, and the marshals are as well, from the reporting that we've seen, very seriously.
And last question, if you could help Professor put this in the broader context for us, because this attack on judges and the judiciary isn't happening in isolation. We've seen the president now turn on Leonard Leo because these ultra-conservative Federalist Society-approved judges are not proving too right-wing enough for the president. But this comes in the context of the administration also going after law firms. It seems very much a part of a concerted effort to attack the rule of law and using the law to defend people's rights. Tell us a little bit about the broader context.
I do think that attacks on judges and attacks on law firms are of a piece. They seem designed to seek to neutralize sources of countervailing authority and opposition to this administration. And if law firms can't take on unpopular causes because they are scared to run afoul of the president, and if judges are scared to rule against the president, then we really have lost any meaningful check on a president. And as I said in my opening remarks, I think if the Constitution is committed to a single principle, it is limits on power, right? No absolute power. And I worry that we are on a path toward few, if any, meaningful limits on the president.
Thank you for your testimony today and for speaking truth to power.
Thank you.
Thank you, Senator Schiff. I will also note that when it comes to rhetoric against judges, that it was Democratic leader Chuck Schumer who stood on the steps of the Supreme Court and threatened the justices by name, and one of many left-wing commentators who's amplified that message is a fellow named Ian Millhiser, who, when the leak of the Dobbs opinion happened, he tweeted out, quote, the draft Roe opinion appears to be as bad as expected, but I'm glad it leaked because this leak will foster anger and distrust within the irredeemable institution that is the Supreme Court of the United States. And I guess he decided that rhetoric was not overheated enough because then he tweeted, quote, "Seriously, shout out to whoever the hero was within the Supreme Court who said, F it," although he did not abbreviate that, "let's burn this place down." That is the angry, unhinged language from the left that has been directed at the court when they dislike the decisions. I want to thank each of the witnesses for joining us today. I want to thank Senator Schmitt for co-chairing this joint subcommittee hearing. Written questions for the record can be submitted by senators up till June 10th at 5 p.m., and the witnesses are asked to respond to any written questions for the record by 5 p.m. on June 17th. And with that, this hearing is adjourned.